directly to Al. Michelle McConnell, Shoreline Planner.
You don't look like Michelle. Oh, I'm sorry, I'm confused.
I will turn it over to Michelle McConnell.
Thank you very much. Good morning, Commissioners. We have been hard at work making all the revised or the revisions that you've requested to the SMP document. And I've got a handout here for you. Oops, yeah, this morning. You both have a copy. I'll keep a copy. Okay, he's got it.
And this is the pick list.
These are a couple of supplements to the pick list. Now, last week, I think that was, I sent you by email the revised pick list, so I did not bring that today, but you should have already gotten that. And
I'll go make some more
actually,
copies of this.
I will post it to the web. I have not yet, but we'll be posting that to the website. So that has, you know, everything through the last time we met with you, which was Thursday, October 1st. These 2 pages are additional supplements to that, I believe it was the October 5th revised pick list. The first page, at the bottom in the footer, you'll see it's called Additional Edits. New item numbers 277 through 314, just continuing the numbering from the pick list. The source column you see is the same all the way down. These are the sources that staff preparation of the revised document. So as we were going through making your requested edits, these are additional things that we came across that we made with the assumption that had you specifically looked at them, you would have directed us. So this is your chance to just say, actually, no, we didn't want that. The majority of them are staff edits that were already proposed in the August 20th staff recommendation. And we went with the general trend wherein when you didn't agree with the proposed staff edit, you specifically noted to, you know, get rid of it. So that's the majority of what's in this list here. There's a few wording changes where, again, you hadn't given specific direction on exactly the words you wanted to see on the page, so we just made note of those here. So that's something you may want to take a look through, and it's all based on the page numbering of the, again, the DCD staff recommendation, which is the document you were using during your deliberations. I don't know that there's anything specific to pull out or draw your attention to. Should be fairly self-explanatory. The second page is the footnote there. It calls it new text. And so throughout deliberations, you gave staff direction to add a definition, add a new definition in Article 2 for a number of different terms, and simply directed staff to come up with something. And so this is the text that we've put together from a variety of sources, which are listed there in the notes column. And if you so choose, I'd be happy to go through each one of these and sort of talk a little bit about how we came up with them. The one that you may want to take note of is on the second page. It's actually got 2 pick list numbers because apparently it got on there twice, 162 and 260. You have directed staff to define the term public waters. And in consultation with David Alvarez, I think we're proposing to not include that as a specific definition in Article 2 because it actually isn't defined anywhere in statute or in Washington Administrative Code that we can find, and it's got some sticky issues that perhaps would leave the county best not being the ones to define it for the first time. And we might talk to Mr. Alvarez a little bit more on that. So if you want to go through the list or jump right to that one, it's your choice, but these are the couple of supplements that we prepared for you, and we're prepared to continue making any additional edits to the document as you so choose.
Let's just dive right into public water.
Well, if you don't define it, then it reverts back to Webster, is that right? And you say what's public and what's water?
Well, the case law, there is case law out there that says that Merriam's third edition of the Webster's Dictionary can be used anytime there's not a statutory definition of a word, yes.
You look under waters and you look under public. And
yeah, and then you combine the two.
Okay.
Is public water is also something that's been defined through case law? Or?
Well, I think it really depends who you talk to. A lot of people will say public water is anywhere you can go with your canoe, and then all different groups have different versions of what it means. But there's never been really defined in case law that I could find. And I didn't do a lot of research on this, I just heard about this on Thursday, but.
So from the department's perspective, we typically say there's waters of the state, and then there's land. And so the land is owned by somebody, and the water is of the state. That's how we operate.
But the interesting thing is the tidelands would be owned
Private
by,
property.
owned by someone, but if the water covers it, then if someone could canoe across your tidelands, I mean, or kayak across your tidelands.
Yes.
Is one of the concerns getting into the navigable waters issue
Well,
that
that's
the
the-
federal government's dealing with right now?
Well, that's what the navigable waters issue. You talk to certain groups, they say if you can put a canoe up it, then it's navigable water.
Right. And that's an issue that's being dealt with on a federal level.
Oh,
in terms
I'm
of
not familiar with that, but.
Clean Waters Act,
Okay.
determining what to do with that term. So it has great implications. Most people would say, yeah, that's navigable water, that's public water. Other people would look at other waters and say, no, that isn't. And then you get to that place in between, and where you draw those lines, that can be a real tricky thing to do. It has real implications where you go with that. Okay.
Dealing with the Army Corps of Engineers on that.
Oh, yeah. Nice.
I can see that that
All
can
kinds of
be
things.
a dangerous course to take right now.
Actually, one other definition, just if you are ready to consider another topic, is the hazard tree definition. That's on the first page. Well, let's see, I guess it could potentially be page 3 of that
Number
staple document.
246.
Thank you, number 246.
Yeah.
So during deliberations, you work to reword that definition, and that's what's shown there as BOCC direction, but you also advised staff or directed staff to consult with Department of Natural Resources. So we did that over the last week, 2 weeks, and conferred with our regional forester, Ross Goodwin. His feedback was that the wording the board had come up with was pretty vague, and he had concerns and cautioned the county against using a vague definition, because of course then you can run into difficulty with interpreting that. The staff recommended definition in the second column is sort of a hybrid of the originally proposed staff language and some of the key phrases that the board came up with. Sent that back to DNR, and basically his response was that looked better, but he still had concerns about the phrase in the very beginning of that definition that reads, that presents a risk to persons or property, and his advice was to take that term out, but that the rest of the definition looked pretty good to him. The other thing is that we switched, I believe the original proposed language was within one tree length, and here we've got proposed 1.5 tree lengths. That is consistent with the policy memo that Department of Natural Resources has issued, and that's actually, at this point, that's their only policy guidance on the issue of hazard tree. Now, they have been directed by legislature to prepare formal guidance on the hazard tree issue, but they have not yet completed that, so it's not available.